My lord, inadvertently the address of the opposite party number 3 has been wrongly typed. Hence, correction is lordship.
Address is wrongly typed.
My lord.
What is this?
My lord, instead of Jajpur district, I have written Jharsuguda district due to oversight.
You have written wrongly.
My
Then
lord.
what we can do?
My lord, I
It was not the mistake in the order by us.
No, lordship. Only correction of first title, my lord.
You can't make a correction in this one. We are making permit you to amend. The permit you to amend. The matter is disposed of.
My lord, matter was disposed of.
So, can we?
Lordship.
Can we? If in the body, if you say, then I can. What is it? Show us from the body something is required. Which opposite party?
OP number 3, my lord.
What is this designation?
My lord, district education. My lord, district project office. It is not actually.
He is a state project director.
My lord, district.
District.
My lord.
We're just trying to help you in
My lord.
the judgment if we can. Nothing will affect your right.
My lord, OP2 will instruct OP3 for necessary correction in the merit list. The name of the petitioner will be included in.
So we have not said anything. We have simply set aside the judgment of the single bench. That's all. We have not said anything that what to do and what not to do.
But as because wrong district has been mentioned due to fault of the petitioner mentioned, hence my lord, Jharsuguda district DEO will be.
Sir, you should have pointed out when the matter was pending.
Due to oversight,
oversight means then what?
I bowed down.
Show us the power. Show us the power. Show us. We are ready to help you, but show the provision of law where we can exercise in a disposed of matter the amendment in the cost title or amendment in the petition after the matter is disposed of. We become functus officio, sir, the moment we deliver a judgment, except to the extent of 152, where is a ministerial, clerical, or typographical, accidental omission. All these things we can do it, but not beyond that. How can we correct it? How can we amend the petition? Show us. Consult any of the senior. If they can show me a provision, I will do. This is not a way to. We can't do. No, you can't do.
Original writ petition, correct address was there. In the original writ petition, which was disposed.
Sir, are you not understanding
Well,
the problem which we are facing? Had there been some mistake in the order itself, we could have corrected it. But you are not showing any mistake in the order. You wanted to really amend the writ appeal. After the writ appeal is disposed of, can we permit a party to amend? I am asking you a very small legal question. Show us. Even 153 cannot be invoked, I believe, section 153. CPC law. To that extent. It also 1.8. Though the instant matter was mentioned for correction of the this bench, I think both of us. Contempt. So why you are mentioning? Has it been assigned?
no, actually, it has to be now the roster assignment, like my lord the Chief Justice is. Let's go to the assigned bench.
Send it to the administrative side.
Yes, has to be placed before my lord the Chief Justice. So
My lord,
Item 1, sir.
my lord, matter relating to violation of the order of the interim order, my lord, of this honorable court.
Sir,
This is not a regular bench.
Sir,
It's not a regular bench. So if you are suggesting that it is a bench where I was a party,
Yes,
then administrative side has to be placed before my lord, and lordship has to constitute a bench.
my lord.
with my brother.
Yes,
that-
Whoever. So please mention it in the registry.
it is item number 1, my lord.
Oh, one. Then.
One, item 1.
Yes. Oh, one. All actually.
Yes, sir, I called it.
Yes, not
Item number 1, sir.
One.
Yes,
Sir, called it.
This
Where
is
is the order?
a violation of the lordship's order,
kindly
Where is
kindly
that?
place the order.
my lord. Interim order, my lord.
What is the order? Where is the order which is violated
Violated, my lord.
according to you?
Kindly see annexure
Order dated 24/3.
24/3/2025.
Yes.
That the disengagement already stayed.
Just
my lord.
1 minute. So, consequently, deduction regarding the portion of the litigation will remain stable. Let's go to the you have state law. What operating portion of the order? What did it show?
No, brief transfer into it. A government brief transfer into it. Second lender was fully. Yes, sir, yes.
My lord, page 13. Page 13 of the contempt application.
So as the portion of the order is
Para 7. Page 13, para 7.
what it says.
The list of the appeal 29th April 2025, constitution direction regarding questioning notification of 23rd October 2024, my lord, and disengagement letter 17 March 25 will remain stayed. Disengagement order stayed, my lord. Thereafter, I submitted the order of this your lordship's order, my lord. They have not allowed to me by continuing my service, my lord, for as a Anganwadi worker.
But the order, the position of the order is stayed.
My
It
lord.
does not mean that your prayer for engagement is allowed.
No, but not really engagement. I have before.
What is the difference between a stay of an order and the order on the face of it?
Well,
Even if the opposition of the order is a stay, does it efface the ratio of the judgment or a declaration of law? So long it is not caused as
disengagement order you see my stayed. So and I am to continue in that portion for more post. They have not allowed to me.
And the engagement letter is also a stay.
Yes.
That shows that in the event you succeed in the appeal, then all this period will be carried forward for your benefit.
Well,
Yes, it's not basic contemplation, but your interpretation gets into exchange. Must understand. It's not there to not to take field that we have. They cannot take this field that we saw them to that. Just went order. So it's nice that.
Yes.
This is how it is stated. But you can't elevate your level.
No,
Everything is
ये lordship's permission mat. मारे ये मान मान
You should not base this content in this way because this information you are happy about. Right. This administrative resource. Because you are saying, I think the case has been finally application finally allowed. judgment set aside and the order has been set aside. What is the difference between setting aside or reversing a judgment and staying it? That fell from my appreciate that. Want to keep it live for that's difficult. But the way you are interpreting, that's extreme interpretation, we have to reject it. I think that is not in your interest. This 7 is for them. They will not take this plea. That 6, we are continuing. We'll take it. Once you succeed in that, everything will flow to you. Be patient.
Well,
I think also appreciate violation of interim order and violation of a final order can be different.
well,
That part is another aspect.
well. Well, contempt will lie over me. Yes, your lordship.
Whole life. You want the litigation to remain in the docket of the court.
No, man.
The contempt jurisdiction, when the court exercises such jurisdiction, the court has to record its promises and exception.
But-
That there is a violation of its, then invite him to explain. In the court finds there is no property material which may remotely constitute the alleged violation of the court. To be dismissed and the if you want, we can dismiss at the.
No, well, contempt application is not place matter. Not place matter.
Yes.
Read appeal. Yes, yes, yes. My lord, my lord. My lord.
Mention the matter before the.
My lord. Your lordship.
This way.
Yes.
Okay.
Yes.
May I please, your lordship? Your lordship, this matter was listed before the lordship's bench on 28th, but got delisted. So,
Give the memo.
Due apology is one orders matter. Your lordship has heard the matter in full. Let it be dictated only. There is going to may face termination. That's all.
No, nothing.
Today is list 26.
Yes, let us see.
My lords, I'm constrained to make a mention. I seek your lordship's indulgence. This matter I'm mentioning before lordship is a tender matter where your lordship the pleadings were complete. Your lordship had taken up the matter for hearing. Thereafter, the state government sought for time seeking instructions for the purpose of seeking instructions. Now, your lordship thereafter the matter has been listed a couple of times, including this Monday, 4th. What has happened they are moving now on Saturday tomorrow. They're trying to hold the presentation after having selected. Now, if your lordship has already fixed this matter to 13th. I'm only praying for the state government to at least restrain, because they have stated before your lordship that they will not take any coercive action or they will not proceed in that matter.
Who is for the state?
State government.
Who is the lawyer?
Debashish, Mr. Debashish, yes. Tripathi
Where
was.
is he? Call him.
He is not available on leave today.
Today he is not available.
Convey.
I'll convey.
Yes.
You pass on the number.
Yes.
Number maybe.
Yes, I'll do that. Because already
Yes.
posted to 13th.
Yes,
So it can
call-
come for
call
orders
the-
at least.
Right. Item number 5 of today's list. Item number
Our incompetence not to reach the matter.
Item number 5 of today's list. May I kindly be permitted to withdraw with liberty to
Withdraw.
file item 5.
Item number 1.
Liberty to file is better.
My lords,
Liberty to
my
file
lords,
is
my
better.
lords, liberty.
Yes, my lordship. Here on the last occasion on 5/8, lordship has 6th of August, lordship has formulated the two questions that are coming up. The impugned order, my lords, is at Annexure 9, page 84. That would be PDF page 181.
Right.
Wherein they have
Where is the other side?
state.
Who? Mr. Tripathi. He is not available today. Says he has not come to the court.
Oh, yes.
Item 1.
See, order dated 5/8/2023.
He has not.
No, it must have been.
Mr. Sasodas, in this case,
No.
is on his legs in another court. Item 1 in some other court. He requested one pass over your loss of time. Let him come. Wonderful.
Will he be able to answer everything? Is he ready? Has he gone through the last order dated 5th of August?
Better if I pray for the matter to be listed next week.
Our only problem is that they may put the Sairat to auction. That's why it was.
When they can.
I'm told that
Any date is fixed for by them.
no, not yet put to auction, but if they
Then
put it, then
Monday if he comes, then he'll have to ask. Monday,
I'll
this
keep-
matter on
yeah.
Monday.
Because it is at your behest, this has
Thank-
been adjourned.
Yes, I understand your lordship.
You will just.
Yes.
Monday.
Item number 2.
My lord, this matter relates to Netaji Subhash Chandra Bose. I have filed, I made 4 prayers. Your lordship kindly have a glance at order dated 22/1/25. They appear, but not filing any counter till today, my lord. 6 months already passed. Order dated 22/1/25, my lord.
Item 2, we have already issued the PWC. Let's give another 10 days time, we'll file the count.
Sir, what is this? They have raised an issue. Oh, it is already on. Yes, sir. They have raised this issue. What is your reaction? What is the reaction of a government?
They have approved the Supreme Court. Supreme Court, other certain points, I'll file a detailed affidavit, my lord. Let me give some time.
They have approached. You approached the Supreme Court.
No, my lord.
Then who
No, not
approached?
at all.
We'll file the affidavit, my lord. Details I have not gone through it.
Affidavit within 2 weeks.
Within 2 weeks, yes.
Item number 3.
Date may be fixed.
2 weeks, yes.
Item 3, sir. Item 3, my lord, your lordship may. I was supposed to file a counter. Your lordship was lacking one.
Counter in the PIL, sir. Why
Affidavit,
this
sorry.
word is
Sorry,
used
sorry,
everywhere by the state?
Sorry, my lord, that should be affidavit.
Should be. It's a public interest litigation,
Yes.
not an adversarial litigation.
No, your lordship.
Let's see, the tender is going to close by this month, your lordship. And the supply of the chicks are going on, and also the security monies are also.
That tender means then why PIL? Why PIL, madam? What are the allegations that what they are doing?
Lordship, then they are unauthorizedly supplying the poultry baths. So they are unauthorizedly supplying the poultry baths.
Poultry?
Poultry baths. The
Birds.
baths,
Birds.
your lordship. And who are also blacklisted, priorly blacklisted.
Then, madam, it is not a
Party.
PIL. Then it is definitely challenging the action of the state for a particular purpose. Then how the PIL comes? They are not floating the tender. They are not doing anything, and they're doing secretly.
No, Your Lordship.
Then
Lordship, the petitioner is the public influencer, Your Lordship.
he's
The
a
public influencer.
public influencer. How
That's
many public you have influenced? Say public spirited person. Influential word, from where you got it? Yes.
Lordship, the opposite party number 2, the Director of Animal Husbandry and Veterinary Service of Fisheries and Animal Resources Development,
Correct.
during the year 2022 and 22-23, 23-24, as well as 24-25, under the state plan for the livelihood support to individual members of WSAG and PBTG district through backward poultry rearing units and livelihood support to farmers. They initiated this um, tender, Your Lordship. And the opposite party number 3, 4, and 5. Among them, 4 was blacklisted priorly, Your Lordship, in the year that is under Annexure 5, Your Lordship. Kindly have a glance.
So your grievance is that the state is favoring only one family
That's
for supply, and this tender is merely an eyewash.
that's
Paragraph 11. If I go through that,
that's it.
have
Yes,
you
Your
made
Lordship.
out a case that in the whenever the tender is floated, it is the same family
Yes, Your
which
Lordship. The
applies,
sibling,
no other applies?
the siblings, the both the opposite party 3 and 4 are siblings, Your Lordship. And among them, one was priorly blacklisted. One of them was priorly blacklisted, Your Lordship.
Blacklisted for how many years?
Let's see, regarding that, but I have annexed that in Annexure 5, Your Lordship, the blacklisted order, Your Lordship. That was in the year 2019, Your Lordship.
No. Blacklisting for how many days or years?
That was not mentioned in this order, Your Lordship.
Then
Only the
What is the status of their GST? We have completed para 10.
that's it.
What is the status? Have you verified? They are all valid, and validity is still persisting as on date.
That's it for supply.
file your affidavit. This is something. Well, 3 weeks.
Item number 4.
Obtain the information whether
Let's-
they are filing returns, whether their registration certificates are valid till date, they are continuing with the business.
Item number 4.
Let's my prayer
They'll
for
file-
Your Lordship is kindly the
Please let
security
them file affidavit. They have a right. They will disclose that what is what.
But the project will be this tender will be going to close by this month, Your Lordship. And if the security monies will be credited,
Let them file. Within 2 weeks, you file. before that. Yes.
Item 4.
obliged.
Item 4 is a PIL for construction of multi-purpose cyclone center. On the last 2 dates, my lords are directed to file an affidavit. The state to
But
file
they
an-
have not.
I have received some instruction. Your lordship will grant me in 10 days time. I'll file.
What can be done? This was done.
I think the 10
There was already this. This is really a third extension. The second extension.
second.
First extension was on 30th of July.
32.
Second extension, my principle is
I also.
pay cost by an order dated 16/7/2025. The speech was directed.
Petitioner is a president of village committee. He has not
He's a-
submitted. He is a president of village committee.
Village.
Lord, he has filed a application before the collector having some grievance against the OP number 6 that he has manufacturing liquor and his wastage water is leaving to the village main road and specific grievances being
There is no drainage system.
no, Lord. And also there is
nor the I do not know
Spe-
the wastewater.
Yes, wastewater is coming.
Treated.
Yes, it is in the middle of the village and also in front of the temple also. That part is not important, Lordship, because
That
main
is
main is
important.
main important is the drainage water. The water is coming to the village road.
You have no grievance if they go on manufacturing liquor.
But in the
front of a
temple restriction is not that because he is a manufacturing unit. It is not selling. He is not selling the retail as retail. Here the OP number 6 is manufacturing, and the wastage is living to the village road. I filed in the month of April, Lord.
This this is again if the wastewater is I may say injurious in many aspects.
Yes.
Why not the treatment plant and all everything is to be done, and the proper drainage system is to be ensured. I think what your pollution control board is doing.
Yes, that. I made party also. Pollution control board also. I made a party. They are also not.
They are not responding.
I have sent also registered application. The application has been sent to registered
Have
post.
you sent it to this person manufacturer?
Yes.
Have you made
No, my lord. Yes, I have sent also. The Lordship kindly have glance page 16. The copy has been forwarded to Commissioner, Chairman Pollution Board and the party also. OP number 6.
Just 4.2.
No, I'm
Yes,
talking about this the instant writ petition.
Yes, Lord.
Have you served the copy on him?
No. It's the first time it has come, Lordship. Notice, then I'll send.
Notice
4.2.
Yes.
Item number 2 and 3.
Yes. There, it is there. Lordship, I have taken the grievance.
Production 800 feet. 800 feet.
60 feet from temple.
The production unit is within 60 feet.
Village temple.
It's temple.
Restriction is there. I have specifically taken these grounds in my application, Lord.
Notice 2 weeks. Returnable.
No.
Yes.
Item number 8.
Here, the present petitioner is one of the bidders in a tender floated by the opposite party regarding providing supplying manpower. Here, the bid document says
there are two things, sir. In a technical bid, there was one bidder who did not qualify, but he was allowed to participate in a financial bid.
That is one.
How? How could it be? I do not find actually any rejection order, but I find a list of the successful bidders who qualified in the technical bid. His name does not appear from. He has not find a document where the rejection is there. But anyhow, it will be presumed that he did not qualify in the technical bid. How can he participate in a financial bid and then secure the order?
As a matter of fact, I got the instruction today that agreement has already been executed with the.
Sir, we will stay the agreement. We will cancel everything if this fact appears to be correct. That a bidder whose bid was disqualified at the technical bid stage, how could he be permitted to participate in a financial bid?
I understand it.
If that is the position, agreement,
everything goes.
Everything goes.
Yes, ma'am. Correct. There cannot be a second opinion. There cannot be a second opinion. Once he is disqualified in the technical bid.
Because the name, where is that list? 6 persons list.
Well, it's page number. That would be at page number. That's 76, annexure 7.
No. His name, last name is there.
Last name is.
No. There is a
the forms
financial
where they
financial
say
bid.
Yes, they say disqualified. That would be at page number 164. Annexure 2 series, first page.
64.
64. Towards the bottom of that page.
Yes, disqualify.
The others are qualified. There are.
Look at it. Where is his name?
This towards the top details of the bidder.
Nishan.
Yes.
Nishan
Yes.
Multi-Service Private Limited.
Nischint.
Nischint Multi Services Private.
Yes, and this is disqualified.
You are referring to Nischint.
No, no.
No, my lord, I am for the OP3, my
I submit that, my lord. Opposite party number 2 has been disqualified. Opposite party number 3 was found to be alive, L1, and agreement has been executed with. Opposite party number 3.
No,
That
no.
instruction I have received today.
In whose favor the agreement is executed?
The
Nischint?
no.
Then
The successful bidder is OP number 3.
what is his name?
Manju Services
Manju.
Private Limited.
G. Manju.
G Manju.
And the Manju Services, the auditors' reports relating to transaction is in respect of Manju Services. According to him, he has been blacklisted.
Well, he had been blacklisted once. Then,
When?
That was in 2021. They say that it has been revoked.
Correct.
Of Manju Services.
Correct.
Now the present opposite party number 3 is G Manju Services Private Limited. The contention of the present petitioner is that in order to
But he has given his financial
of
solvency
of
of
Manju
Manju
Services.
Two different entities.
Yes.
Two different legal entities.
Yes. That is
How
my
can it
second
be?
limb of argument.
How can it be?
They have, I'll have to give an answer.
How can it be?
I understood.
No.
Only I wanted to submit to your lordship that this morning I received this one. But I'll have to give an answer.
They think
Certainly.
everything they can do it. No. We are staying. The challenge is made to the letter number 1346 dated 24/7/2025, by which the opposite party number 3 was
Millards, here I am a bidder, Millards. I had the opposite party number 3 had floated a bid. Millards, under that floated a bid, Millards.
Floated.
Tender, a tender.
Okay,
It was
floated a
floated.
tender.
Yes.
Say,
Now, Millards,
tender.
in that bid, Millards, what is that condition is that I have to use the online portal. Now, Millards, I use the online portal. I prepare all my documents. Millards, may see annexure 4 for a moment.
Yes.
This is my technical bid that I prepare with the intention of dropping the bid. Now, Millards, annexure 5. This is the EMD. I prepare for dropping. Now, Millards, annexure 6. I try to drop the bid. There is a technical error that I face, and Millards may see I deposit the
Status is failure.
Yes. Now, Millards may see annexure 7. Before that, Millards may come to page 120 for a moment.
Yes.
This is deposit. I have it from my account. The amount has been transmitted.
Yes.
But there it is showing us failure.
Yes.
Now, annexure 7, I immediately approach the banker of the opposite part number 3 because of this failure, saying that I'm not able to drop my bid because of these technical errors.
Yes.
This is my mail, Millards. I do it prior to the closing time. Now, Millards, next annexure, Millards, I seek an extension. Give me 1-2 days extension. There is some lag in your website portal because of which I'm not able to participate and I'm not able to drop my bid. I'm presently working another project nearby, so my bid is very responsive. And I say that you please allow me 2 days time. Now, another when this was not responded to on the same day on 28/7/2025 at page 129, I issue them another letter. Now, they closed the dropping time. They do not allow me to participate. I intend no action has been taken on this letter. Now what they have done, they have opened the technique that the bids have been opened. So they have proceeded for technical bids have been opened. So they have proceeded further, irrespective of my application.
Have you served the notice on this infrastructure?
Yes.
Yeah. Have you served the notice on this?
Opposite the state is all the parties are state.
Yes. Who is representing?
And to assist your lordship, I have made the 2 pages of note, Your lordship will permit me, I will. My lord, adjudicating authority under
now after the amendment.
My question. Just a 2 pages of note. Okay.
Give me that dynamic transaction for partition.
Milord?
Annexure 5.
Milord.
Page 8.
One notice.
Milord.
Page 85, your lordship.
After order was passed under section 24, Milord, this notice was issued. Just I will.
Yeah. When is the final order pass?
The final order passed, I am filing it with an affidavit, my lord. So these are not readable.
14/2000. Sorry, order.
My lord. This order, my lord, was uploaded and I got it downloaded, my lord. And unfortunately, some of the pages are not readable. Most of the pages, my lord.
You have a copy of that order. You have a copy of your.
No, Lordship, we don't have the copy.
The next from your authority. Those are not legible.
No, Lordship.
They're not legible actually. So I couldn't file it.
Then what to do? Is there any problem for the appeal against the order?
No, my lord.
Yes, Lordship, we have to file an appeal before the tribunal.
Tribunal is constituted.
Yeah, Lordship.
This tribunal.
It's in Delhi, Your Lordship. That tribunal is at Delhi.
Okay.
I'll be getting the exact details of that. That's
$46, my lord. Section 46. It is directed against order passed under section 26, my lord.
Go before the authority.
I am here, my lord, under section 24. And the issuance of notice, and I am challenging.
Because notice was under section 26.
My lord.
the prayer is also
Partition is under section 26.
My lord.
Then why against 24?
24, my lord, my contention is that the Benami Transaction Act is not applicable to me.
Or
Because, my lord.
the
My lord.
notice was the first step to be taken
My lord.
for before the adjudication.
My lord.
The adjudication has already been done.
My lord.
Can you go at the very why you did not?
Now, my lord.
Before the appellate authority tribunal, tell them that they have not considered the entire thing in the perspective.
24 is not available. Probably I am not able
Probably you have not understood what is passing in mind.
My lord. I'll be grateful.
Section 24
My lord.
is available for notice and the attachment to be given.
My lord.
It is a precursor of section 26.
My lord.
Then the adjudicating officer adjudicated under this section 26 after the notice under section 24 is given. Now adjudication has already been made. You participated in the adjudication. Yes, terminated into an order.
My lord. My lord. 24. My lord.
26 terminated. power. And once it is
26 is pending.
no
26 is pending. This is
no.
Milo. I am assailing the notice.
You have already dated this. In your note, you have said initiating officer on 13-3, and then you are referring an order of the subsequent orders.
That is 24-4, my lord. That is why I am probably not clear, my lord. That is notice under section 24-4. Now, what I am assailing is the notice under section 26, my lord. That order I couldn't supply that 24 order, my lord, because that is not readable. Only notice was issued in 26, my lord.
He has followed whatever is provided in section 24. Ultimately, he has to make all the statement of the claims, constituent of the facts, and then send it to the adjudicating authority for taking any steps, which he has already complied. Now the adjudicating authority has taken.
Milo, pending there. Your lordship is correct. Milo.
Now they have issued a notice.
Milo. That is impugned before your lordship.
Your lordship. No,
No.
lordship is
Final
notice
order.
number
Only
26(1)
notice
has
is
been issued. He has to appear before the assessing officer on 26/5/2025.
The adjudicating
Authority, Calcutta. Page number 86, your lordship. Let him appear before.
The initiating officer has not followed the mandate of section 24. Take that. While you are here.
My lord, I am assailing, in fact, the proceeding itself. I understand what your lordship is referring to, but before your lordship, my contention is that Benami transaction can't have any retrospective application. I will raise my points.
So I am aware of Venkateshwar Kumari's judgment of the Supreme Court,
Milo.
and then overruled by subsequent judgment from 1991 onwards.
Milo.
I am conscious that it cannot be given a retrospective operation. It is always a prospective in nature. Now, when these amendments have come into force,
Milo.
now the question is that whether these amended portions could be considered to have its operation from the day of enacting the Benami Transaction Prohibition Act or from the date of bringing an amendment.
Milo.
Is the amended provision should have a retroactive effect or prospective effect?
In fact, that question is still open. It's not been decided till now. Honorable High Court of Calcutta.
What is the effect of the amendment?
It is still pending before Honorable Apex Court.
Amendment connotes.
In fact, that judgment which your lordship is referring to, that Contempt will come. Honorable High Court of Calcutta has dealt that there can't be a retrospective applicability of Chapter 4, that Section 24, 25, 26, etc. And which was carried forward to Honorable Apex Court. In the first instance, Honorable Apex Court has upheld the judgment of Honorable Calcutta High Court. Subsequently, in a different context, that order was recalled and still open for consideration.
Where is the Calcutta High Court judge?
So I am giving my office copy. This judgment of Apex Court, I couldn't lay my hand on that High Court judgment, but that has been referred to. That is the Honorable Apex Court judgment which has dealt with that. Paragraph 9, your lordship may kindly see. I have folded that page. Another copy for my Lord Justice Raman.
Sorry. Put the other also.
Milord, your lordship may kindly make a
Keeping
prayer.
all the points open.
Milord, expedite help.
You are going to reply to
No.
under section 26?
No, I have not. I have not.
Time has expired or it has not expired?
We have taken time for filing.
So your time
Time
has
is there.
expired.
No, time is there.
Is there? Proceeding under section 24 of the Prohibition of Illegal Property Protection Act 1983
the proceeding.
Yes. First, how soon you can file?
You have to go to.
We further request the adjudicating authority to bring the
Item 20.
Made clear. Your Lordship, here the petitioner is a works contractor having very small turnover. What has happened? So while filing its periodical returns in GSTR 3B for a particular through online, there is an inadvertent mistake has been committed by its accountant while filing the online return. So there is a non-putting of a dot mark between the rupees and the paisa.
So it becomes whole the rupees.
Yes, that 1 lakh become crores, Your Lordship. Your Lordship.
Dot is so important.
Your Lordship, at Annex 3, case 27, Your Lordship. As a much more on the multiple times of its turnover, Your Lordship. So what has happened? I'm just appraising, Your Lordship. What has happened? So he could not.
Similar aspect happened to
Your Lordship,
happened as
but this is an unfortunate matter. Your Lordship, recently, Your Lordship, Your Lordship, why I'll show. Let me show Your Lordship. Recently, Your Lordship has passed the order as per 161 after extensive argument by both the sides. Now, Your Lordship, for a moment, Your Lordship may kindly go to the date chart. What my learning seniors filed, the date chart along with page C, Your Lordship. This became infructuous, Your Lordship. Why it became infructuous, Your Lordship? After appeal, Your Lordship, adjudication order was passed in 2024. He has approached the appellate authority, filed the appeal. The appeal has been rejected. After rejection of the appeal,
Your Lordship,
he has filed the appeal in delay. The rejection was on delay. After filing, after rejection, what he cannot achieve, could not achieve directly, he wants to achieve it indirectly. Why, Your Lordship? 2024, the adjudication order has been passed on 18/10/2024. He has filed the appeal on 12/3/2025. Page C, the date chart. On 12/3/2025, he has filed the appeal. The appeal has been disposed of on 29th March 2025. He has filed the rectification application on 21st April 2025 after disposal of the appeal, Your Lordship. And Your Lordship, 28/4/2025, even the adjudicating authority by adjudicating that 161 has issued the show cause notice. And after that, 17th May 2025, the 161 petition has been disposed of. On the last occasion, Your Lordship might have remembered, on the last occasion, Ms. Tripathi has argued that 6 months, Your Lordship, there is a period within 3 months it is to be filed and it is to be disposed of with 6 months. And after extensive argument, Your Lordship has not adjudicated the matter and passed this order that let the appellate authority decide this issue.
This dot was not issued.
Your Lordship?
This dot was not issued.
Doctor, not only dot, Your Lordship, here, the petitioner's counsel's argument is that dot. But it is to be adjudicated.
I think does not mean that the assessing officer will not go the other aspect. He can definitely verify it on the top.
Your Lordship may kindly look into the adjudication order.
Mysteriously done.
Your Lordship. Your Lordship may kindly turn to.
I'm answering.
Kindly turn to the adjudication order for a moment. How the opportunities have been granted. Sufficient, page 35. Sufficient.
Dot relates to many transactions or 1 or 2 transactions.
Okay.
Your Lordship, kindly have a glance to this.
And for what period it has been reversed, it is to be verified. It is not that dot. Sorry, I'm sorry.
Asking as assessing authority. I'm just asking as an accountant.
Your Lordship, kind have the adjudication or that ITC analysis is there.
No, why I'm
There are 2 to 3 invoices in a particular month because the return period is monthly. And in the monthly return, my ITC actual as per my books of accounts 1,07,000, 1,07,000 each. If I, while putting that 1,07,000 amount in that return copy under CGST and SGST, so the dot was missed. So that became 1 crore. And whatever the discrepancies on account on which they have raised the demand, the same differential amount.
Must be relatable to
Yes.
1 or 2 supplies with regard
Minor.
to
That is. Yes.
same commodity.
Absolutely.
Commodity.
Yes. Yes.
Value is must have been reflected in tax invoice.
Minors.
That is what I'm
Absolutely.
That is why I'm asking it.
That ITC analysis also this lot.
Corresponding restitution should also be paid from a supplier or the purchaser.
They have made 107. Actually, what my books is reveals that they have uploaded. That is not dispute here. Your Lordship, kindly have a running page 34. Your Lordship, kindly have a glance.
You could not get.
Yes. Supplier has.
He's so involved in his case, does not really go into any other task.
Listen carefully. Listen carefully what
reflected a transaction.
But
what 1,70,000. But there was some mistake that we could not put at all.
Minutes.
So it becomes 1 crore 70 lakhs.
Minutes.
Now this transaction is with the third party.
Minutes.
So they can also cross verification from the third party whether what is the value of this transaction.
That is 1,07,000. It is very much there in the order.
They could have. That
Yes.
is what I'm saying.
Yes,
he has also discharges obligation.
Yes,
of putting that 1,07,000.
Minors.
There is some case which you can argue on that basis.
Your Lordship.
Have they taken as cross verification? Because everything is on portal.
That is exactly your Lordship. That is running page 34 reveal that their adjudication order. They have made the analysis of ITC. Corresponding verification corresponding with the supplier's compliance, which is reflected in the portal, your Lordship. Running page 34, your Lordship.
What they had.
So they said that is the difference between the what supplier has said 1,07,000 and yours is 1 crore 7. That is the difference amount they have raised the demand.
Your Lordship, page 35. 3 opportunities have been granted. How it can be, Your Lordship, why I'm saying so? Let him file appeal. It required adjudication.
We go into this. But if the supplier has said I have supplied 1,07,000, he has wrongly shown that 1 crore 70 lakhs. Now, from where the material comes?
161.
You must have sold those 1 crore 70 lakhs for.
Your Lordship, I can understand.
Nothing.
Your Lordship, in
Bank
origin,
account shows.
Your Lordship,
Bank account shows.
Your Lordship, sufficient opportunity has been granted. He has not availed. Sufficient opportunity has been granted.
He has not taken the.
That might be. But Your Lordship, after in the adjudication proceeding, what I respectfully submit, what I respectfully submit, Your Lordship, this is factual adjudication. This requires factual adjudication.
Honorable Apex Court has observed in case, one case.
This can be termed actually a silly mistake, but turned out to be a huge.
Your Lordship, that's maybe
no point in
verification. Everything is done. The figure is
no cross verification. No cross verification. In
merely because law is in your favor. Fact, can you?
No. I'm not. Your Lordship.
Do the needful.
But only one thing. It is required verification.
Do the verification.
Your Lordship, in which proceeding? Your Lordship, that a question come to my mind. This 161. Your Lordship.
We are reopening every proceeding.
Your Lordship, because Your Lordship, this is appealable. This is also appealable. He can say.
Mr. Mishra will do one. We will ask him to appear. We'll keep this matter pending. Your authority do and give a report. Let us see.
What my respectful submission, Your Lordship, 161 is appealable and not require any requirement to deposit any pre-deposit.
We are taking up as an alternative. mere alternative remedy is not taking away the rights
Your
of the High Court.
Your Lordship.
We are enjoying, we are asserting and exercising our right.
You give a report, let us see.
Yes, if this
Give a
fair and cross verification have been done, then what more?
Your Lordship, then Your Lordship.
And difficulty is the assessing officer you are saying. Now there are decisions on galore. If the appeal is dismissed on the ground of
technical this
the
limitation.
whether it takes away the right of the initial authorities to review sort of.
It's not constitute an appeal. Rule says.
Right is not extinguished. It is only the remedy which is
Your Lordship.
restrained.
Your Lordship. Your Lordship.
Opening the big
No, Your Lordship. No, Your Lordship.
Whether it closes.
No, Your Lordship. Your Lordship may keep it pending. Let him cooperate in the proceeding. Your Lordship, let it be verified again. Your Lordship, after verification.
Of the litigation. Whatever is available.
He is cooperating, Your Lordship. Any proceeding, in any proceeding is not cooperating.
We have said. But I have said. We will ask him to appear on a particular date, suggested date. He will go and produce all the records. Your authority will
verify, whatever you want.
Your Lordship.
Have your conscience clear.
Your Lordship.
And if you find that
Your Lordship, I'm
not
not on the way, Your Lordship.
accidental slip,
Your
something has gone.
Your Lordship.
Previously, we had the conclusion that the zero has an enormous value. Its value is enormous. So, if you put zero after any numerical number 10 times. So, but now I find that dot has a value.
Your Lordship. Because the dot reduces the value.
The
So
last
zero
figure goes.
increases and
Yes.
Your Lordship, why I'm submitting this and I am agreeing with my Lord Justice because if Your Lordship will set aside this matter, this will be Your Lordship. So let it be here. Let it be here. I let him cooperate because he is not cooperating in any of the proceeding. Let him cooperate. Any proceeding, Your Lordship may kindly look into any proceeding is not cooperating.
The small complaint have been temporary accountant. So
Which paragraph you have?
And after 14 months,
Your
the reversal has been made.
Which paragraph? You have stated this. In your pleading, have you taken this plea?
Yes, Your Lordship.
Which paragraph?
Your Lordship. Page 5, para 6, Your Lordship.
10.
Para 6.
Para 10.
Para 6, Your Lordship.
Para 6.
Oh, the last para.
Yes,
That it is pertinent to mention.
Yeah, Your Lordship. Because everybody will come up.
For this particular purpose, let your authority do the verification.
Your Let it be kept in pending.
Further investigations before the authority, then submit the report.
Your Lordship.
Is the investigation going on? No.
Your Lordship.
Is the matter pending before your adjudicating authority?
No, madam.
It is terminated. So he will go for this purpose and.
Your Lordship. Your Lordship.
Yes, to verify of this and submit the report.
Your Lordship. So that it will not be precedential.
Then if need be, he will modify his order under 161 and for that particular aspect only.
Because of the facts, we are adopting this particular the methods. We should not be treated as a precedence.
Because that 3 months, 6 months, many issues are there.
Just
Your Lordship.
Of rendering the justice.
How many days you will take?
Your Lordship, let a date be fixed.
Date will be fixed. You will go there. How much time you will take?
3 weeks.
3 weeks.
2 weeks to 3 weeks.
No, so that
3 weeks. Your Lordship, 3. Your Lordship.
Up to 4.
Your Lordship.
Up to 4 weeks. Item 21.
Cancellation.
Yes,
Yes.
Pastoral matter item number 9. Item 9, sir.
Sir. Yes.
Millards. I was at bidder Millards. I had shown. Annexure 4 Millards is the technical bid that I have prepared to file.
He is unable, earlier within the time. He has emailed you also within the time that I am unable to upload it because of the technical glitch.
But technical
You have to
glitch,
find out whether there was any technical glitch or not.
yes,
If
that
it is, then how can you deprive? And he has given those documents.
Screenshots
have been given.
screenshots have been given on the very last day.
before time.
Before 10 at 3 p.m. he has given it.
So what? And the timing was up to.
Up to 5:30.
So
that I don't dispute. I'll
and
just
he has
take
given the
instruction
email
whether
also
it,
before that.
yes,
You could have opened it.
I'll take instruction.
He raised objection also.
And you don't proceed on that basis. He is deprived, then you cannot proceed. Have they proceeded anything?
They have opened a technical bid. The next steps they have already started.
Proceed for a
A technical bid was opened on 29th July. Financial bid, I have no instruction. Let me take instruction whether it has been opened or not.
because he has to qualify in the technical bid as well.
If not
I'll
open.
find out with the authorities. Your lordship may grant me some time.
When can you? When can you
A
get?
week's time. Right.
Then we have to pass an.
Yes, yes.
If it is Monday, it is better.
But can it
If
be
it
on
is-
Tuesday? On
You
Tuesday.
sure that connection
Yes.
is got.
Wednesday, Millards. Wednesday.
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 But in the,
I'll
just keep on going. No, just keep on going. Till populate the message.
yes. I'll
Millards, only one thing, Millards. Another writ of similar nature and similar part of the tender is filed. That is WPC number 21996, not before the Honorable Court today. But it has been filed and defects are cured, Millards. I am giving the number that may be listed along with this.
That what could happen.
No, Millards. That is because it's the last portion I'm mentioning. The same bidder, same problem. Millards may find that is there. In my bid petition, it's mentioned. Two tenders, same problem. Much obliged.
Item 22.
May I please? Honorable single judge dismissed my CMAPL
What is this CNA here?
restoration application. My writ petition was dismissed
What?
for default.
After how many 996 delay?
Delay.
Yes, delay. What you were doing?
Lord, in fact, in 2014, this writ petition was filed. This lady, after getting married in 2019, could not keep touch with the matter. Thereafter, the corona period for 2 years. In 2022, one date that was defaulted and Rani Council could not appear. That was dismissed, Lord. And thereafter, due to some family problems, now she is residing with their parents.
The order, my lord, passed by the honorable single judge, my lord, wherein without being implemented them as party, my lord, eviction order has been passed. And yes,
yes.
my lord, our state already enacted that 2017 Act. I am just handing over to lordship. My lord. Under section 3 of the Act, my lord, that the land right is to be given and they are to be identified. And under section 4, lordship, kindly have a glance. where they are to be settled, my lord. Section 4, page 7. My lord, subject to other provisions of this Act, the land rights conferred under subsection 1 of section 3 shall, as far as practicable, provided in situ and as is where is basis, provided that where the state government decides that the site has untenable settlements, in such circumstances the slum dwellers shall be rehabilitated elsewhere. Section 5 is very important, my lord. Section 5 says that all proceedings relating to eviction of slum dwellers pending on the ground of unauthorized occupation before any authority or court under any state law shall abate on issue of certificate of land right under this Act. My lord, in the appeal, my lord, the concerned authority at page 17, my lord, page 17, the executive officer, Jaleshwar Municipality, my lord, issued certificate, my lord, with regard to that eligibility certificate to get land rights, my lord. Page 17, in terms of 2017 Act.
Yes.
My lord.
Have you constituted a committee?
That I'll verify from the.
My lord, pursuant to the said provision, my lord, already we have been issued eligibility certificate. My lord, land situated near the railway station, my lord. Jaleshwar municipality outskirt, near the railway station, my lord. Baleshwar, my lord. Baleshwar. Municipality area. Municipality area, my lord. Under the Jaleshwar municipality vicinity, my lord.
But this is dealt with in a different manner by the civil.
My lord, because
In a particular day, have you stated all those things in your requisition?
my lord,
Have you treated all this?
my lord, we are not party before the single judge, my lord. Honorable single judge.
They were not included
And
as part.
my lord,
Single bench has not disposed of the matter.
my lord, that the read
How
petition.
can you maintain an appeal if you're not a party?
My lord, I have filed an application, my lord, for seeking leave from your lordship. My lord.
For the enclosure.
My lord, we are the, my lord, slum dwellers, my lord. We are the enclosure, the read petitioner. My lord. My lord. My lord, that is the fact, my lord. My lord, there is no time, my lord, within.
By the scheme for paper.
No, my lord. No, my lord.
We are asking whether any committee is constituted. Then, unless that land is settled, what is your right to reveal the property?
My lord, one certificate.
Then what certificate?
One eligibility certificate in terms of, my lord. My lord.
Bigger section. That does not mean that certificate is sacrosanct in all such.
And not only that certificate, my lord, they have given house number. They are collecting revenue from us. And at the same time,
Revenue? It's a government land. Or it is a private land.
Government land, my lord. Government land.
This is when they are there. They have from the very old one or the.
No, my lord. It's my lord.
You are recently enclosed.
Is it so that you are closer?
My lord.
Are they defined? Are they coming within the slum kilometers? Please go to the definition, please, because it is not. If somebody has just encroached upon the government land, then immediately proceeding is initiated. It does not satisfy some slum.
My lord, there is no proceeding at all. The learned honorable single judge directed to evict us within 10 days, my lord. And the next 2 days, my lord, it will be completed. And directed, if the appellants are not evicted from the land, my lord, then the Tahsildar will face contempt proceeding. My lord, again that 1/8, my lord, order passed again on 1/8. My lord, we have been intimated.
On Monday.
Item 34. You'll also be direct the government advocate just to oral instructions not taking courtesy action. In item 26, my lord, Mr. Das is there, Pastor Das. Then is the case, your lordship dictated the order and then it should not be passed, my lord, before vacation. The lordship can have this matter once again. Your lordship.
My lord, till Monday, I may be protected, my lord, till Monday. Till Monday, my lord, we are going to be evicted from the land, my lord, within next 2 days. Yes, yes. All
My lord, could I? My lord, item 33 on interim orders till the next day, my lord. Yes, my lord, there is. Income tax department.
Oh, income tax. Whoever.
Mr.
Oh, they are class of the cases has gone, so they have also.
They are.
For them extend
Lordship, they have not responded.
Ma'am.
My lord, item 34,
Lordship.
my lord, the entry order operating against me. The next Friday is either Thursday or Monday, my lord, either Thursday or Monday will be received. My lord, but Mr. M.R.PATHAK is there.
Extended. Extended and yes,
Yes, Lordship.
and any extended date may be given.
Thursday, my lord, or
26th,
26.
25th or 26th September.
Item 1.
Last occasion, look, that is direct for the continue to file his affidavit. They filed it on this Monday, you know. I'm serving a copy on the petition, my lord.
So could affidavit I have already filed. Yes,
My lord, he has a copy.
I have already received, and pursuant to that, I have already filed the reply rejoinder.
The rejoinder copy may be given.
Yes, I have already solved.
There is no order complaint of
So that has been annexed to Annexure A. Content. Paragraph 5.
yes, what you are saying. Well, he has said in paragraph 3 that this the debate talking about
My lord. My lord, this order was of the year 2023, my lord. My lord, may kindly have our affidavit, my lord. It is a flag B, my lord. Flag B, my lord. That's the affidavit filed by the Contempt, my lord.
Flag B.
Flag B, my lord. B for Bombay. So that after that order was passed in 2023, a number of writ petitions came to be filed, my lord. We have annexed those orders. My lord, may kindly have my. Yes, my lord. My lord, the encroachers, they filed a number of writ petitions. They were disposed of, my lord. In one particular order, a directive was also given that the proceeding should be stalled, and all that happened, my lord. Now, my lord, may kindly see paragraph 15 onwards of our affidavit. The last writ petition, my lord, paragraph 15 onwards, my lord. 15, 16, paragraph 15 and 16. My lord. The last such writ petition came to disposed of on 3/7, in the 2024. After that, my lord, dates were fixed for eviction. My lord, and somehow, my lord, and the last date it was fixed for eviction, my lord, was on 3/7, 2025. My lord, 25. After that, my lord, there's an amendment was made to the OGLS rules very recently, my lord. An amendment was made on 19/5/2025, my lord. Where, my lord, it was held that any person who has less than 1/25th of an acre is to be treated as a homesteadless person, and the government, and if an application is made, government may settle some land in his favor. So all these encroachers, my lord, they filed application after this amendment. So now, my lord, their applications are pending. So, my lord, we are asking for some more time, my lord. Once the applications are disposed of, if they are found eligible, they will be settled elsewhere.
Where is the scheme or the rules which are.
My lord, that also we have annexed. My lord, we'll see the amendment that
Whether it includes the person against whom an order of eviction has already been passed, or it does not include those persons against whom the order of eviction is passed.
Well, they have made an
I am asking you, sir. I am aware of many legislation that comes giving the protection. That in the event they are found to be in possession of a government land without any operating perspective of time, the government may settle the land in their favor. But there is always a rider that in the case where the proceeding has already culminated into a final order of eviction, those would not come within the permit.
Yes, my lord. My lord,
So
all
if that even throughout the scheme that sometimes it so happens that those orders will be regarded as a nullity as well.
No, my lord, there is no such provision. That's my lord, page 28 is the gazette notification where the amendment was made.
Page
28, my lord.
Yes.
This is the amendment. My lord, there is no such provision. Like my lord was saying, there is no such provision. All I'm saying, my lord, is but all those encroachers, they have filed application. So we have to dispose them of.
There are two aspects of it. You are there to conduct the proceeding or regulate the proceedings. Mere institution of a proceeding does not mean that the order of the court to be whittled down, or to be undermined, or to be thrown in a dustbin.
No, my lord. No, my lord.
Merely somebody has got there and asked for an adjournment does not mean that you will not carry out the order.
That's, they have not asked for an adjournment for more.
Please tell me whom you will give a sanctity, to an adjournment petition or to an order of the court.
Well, definitely the order.
Then why it is not done?
Then my lord may kindly ask me sometime, a little time.
Why you will not do? That shows that you have a least respect for a majesty and the sanctity of the court.
My lord may call the matter next week, my lord. Within that time, the order will be compliant.
We are not accepting your explanation when we are issuing a rule.
My lord may give me some time.
We should not pass an order for punishment.
My lord may give me 1 week's time, my lord. Within 1 week's time, my lord, we'll ensure compliance.
How many times you require? You are so complacent that somebody claims and drops. Ask for 2 months time, you are so good given a 1 month time. And pretending that I have curved, I have curtailed, I have embraced the time.
No, look that.
That's not your gesture. Why you will not respect the word?
Yes, my lord, we are bound to respect. My
You
lord,
have to implement it.
Yes,
You have to implement it.
Yes.
The order was very categorical that the moment they give you a certified copy, you have to execute the judge.
Yes, my lord, so we will implement, my lord. Only 1 week's time will be given, my lord. I will ensure, my lord, it's compliant. 1 week's time.
And you have got no adequate police person, then we are asking the central forces to be there. If the state police is so incompetent not to render, they don't have the adequate police person, then the central will get.
My lord,
we are
1 week's time. My lord, quickly grant me 1 week's time. My lord, I will see to it, my lord, that department. 1 week time is only what I'm asking. Simply add this matter for 1 week, my lord, I'll ensure, my lord, the matter is compliant.
Your lordship, this.
We have to comply with only some type 1.
Despite the hearings are complete.
till 26th August because the person is staying at Surat. He will come on 24th and I will file the substitution petition on 14th.
No, this has abated. What to do?
I will file
Then application, then we'll have to record the abatement. Who has died?
the OP number 3, 4, 5 and petition or 2.
So, what is the nature of the claim?
Nature of the claim direct declaration of right, interest and information.
Then, sir, the relief is indivisible and inseparable. Then whole proceeding will abate.
For that only I say.
Then we have to record the abatement. Then you file an application, whatever.
Oh my.
Though the direction was passed on.
Item number 3.
May I please, Your Lordship? On the last occasion, Lordship had this matter since
What?
the
Opposite party has come.
yes, yes.
Appeal to one of them.
Have you served the copy on all?
Notice was issued, my lord.
Yes, notice has been given to all.
Yes, notice was issued.
Served. Has it been served? Sir, after 25/7, you were directed to give a notice. Where is your affidavit of service?
Notice on
You are representing whom?
Yes, I'm representing Malik Rabi Malaj. He's opposite party number 2.
Opposite party number?
2. Malik Rabi.
No. Opposite party number 2 is Gurubari BB. Malik Rabi is opposite party number 1.
Bye. PC my lords is
No, opposite party number 1, my lord.
Gula Bibi.
Gula Bibi.
No, I am looking at
Gula Bibi,
file you have given.
Gula Bibi, she is dead and
Huh?
she has been
DPT is it?
substituted. Deleted.
What is the cost title? Is 10083. This is the cost title. Yes, look at the opposite party number 1. Where is the Gula Bibi or Devi?
Consolidated.
Huh? Sir, you have not filed a consolidated cost title because the cost title which is appearing on
but
your
that
application.
is a defective code. It has been filed, but it is
Because the
defective.
opposite party number 1 is a Malik Rabi.
Malik Rabi.
Then
Initially, my lord.
Gurubari Bibi is opposite party number 2. Sorry, Sabiran.
Initially, Gula Bibi. Yes, my lord. Initially, Gula Bibi was the opposite party number 1. After his death, since her legal heirs are already on record, only that is Malik Rabi. Now he is the opposite party. Petition number.
No difficulty. Her name was deleted.
Yes, but her name should be there. Since dead, it should be written there. That is the.
And what is it, Gurubari Bibi?
Gurubari Bibi and others are concerned.
Yeah, these opposite parties are who in the suit?
They are the defendants.
They are the defendants. Principal defendants.
No, some were the pro forma defendants and
Who are
some
the
were
pro
the
forma?
Pro forma defendants were the present opposite party number 8 to 14.
Now it's become 7 to 40. By
Now 7 to 30.
30.
So
So far as
they are contesting together or by a separate set of lawyers? In the trial court?
Before the trial court, they are contesting the suit. The suit was
Suit means by filing a common written statement or separately they are represented by the counsels. I'm just asking you.
Yes, my lord.
Have you annexed the written statement?
No, written statement I have not annexed. The decree which was passed, my lord, that has been annexed.
Where is the judgment?
The judgment is annexure 1.
Then again, which order you have filed this?
What has happened, my lord? The suit for partition.
Huh?
Partition suit was disposed of. The contesting defendants, they.
Please.
My lord, the suit
More
was decreed.
specific.
It was decreed. It was decreed allotting.
In what form?
It was decreed.
In what form?
On contest, my lord.
Sorry? In a partition suit, sir, there are 2 stages of degree. I'm just asking you.
That I am going, my lord. The preliminary decree was passed.
Correct.
Thereafter, the appeal was preferred by the contesting defendants. Appeal was dismissed. Thereafter, the application for final decree was passed. So, when the final decree proceeding was pending, consolidation operation came into notification was for consolidation. Thereafter, the defendant filed a petition to abate the final decree proceeding since the consolidation has already started. So, the trial court passed the order dropping that final decree proceeding. Against that, the revision was preferred. In the revision, it was.
Can a revision lie?
Revision.
It was refusal to pass the final decree.
Yes, sir.
Then whether the appeal would lie or a revision lies. Tell me.
So at that time, my lord, the revision was preferred.
That time will not do, sir. You'll have to answer.
No, it should have been the appeal. But
so
The revision was
It is
filed.
under appeal under section 96.
Yes, well, that
Why then the revision is not maintainable then?
in the revision, that order was confirmed. Against that order, the present challenging both the.
How the revisional court under section 115A.
Yes, my lord.
How the revisional
Well,
court?
my contention is
where is
that
the order of the trial court?
the trial court order dropping the proceeding is annexure 4. Your lord will get at page 31. It starts on 32, my lord. The relevant portion.
Is the preliminary degree executable? I find this word.
Yes, sir.
Challenging the executability of the preliminary degree. Is the preliminary degree executable?
No, unless it is final decree is passed, my lord. But that petition was filed when the final decree proceeding was pending.
Where is the judgment of 74, the CLT? Where is that judgment?
So I have a copy of that. The laureate courts below referred to para 5 of that judgment.
In 1992. It's opened out.
In this case, what has happened? Consolidation. The consolidation proceeding has culminated into any final order.
Yes, in the consolidation, what has happened in the preliminary decree, 3.5 decibels were allotted. But in the consolidation, only 3 decibels has been allotted. That is the dispute. So may I pray on?
You challenge that particular order of the consolidation. That authority in a consolidation proceeding, you have a right to challenge it. Why? In a suit.
But not suit was not filed challenging that judgment. It, so since the law is that after coming into operation the consultation proceeding, the
Whether
final
the
decree will
decree,
not.
whether the decree passed by the court gets immediately nullified, I am asking. I am not aware of the provision. I am simply asking you to bring that provision.
Yes, sir.
Whether this consolidation provision
Operation the consultation proceeding
completely whittled down or throw away whatever the decree is passed.
no, so far as decree is passed, my lord, on coming into a consolidation operation, decree passed, that will not happen. If the suit is pending under
So
section
if there is a
34, this,
conflict, if there is a conflict between a decree and the consolidation proceeding, order in the consolidation proceeding, which will prevail?
no, decree will prevail. That is the, because on view of
This may just clarify.
This was a case where the parties themselves have agreed to vary the terms of the decree. They also executed a sale deeds apropos the said order. So if the parties have chosen to abandon or acquiesce or waive their right, then the court has said that now it is too late in a day to open it.
But that is exactly what has happened here.
It does not. The parties are contesting.
No, but what has happened here is, my lord, the facts are squarely covered in as much as here also, my lords, the parties voluntarily participated in the consolidation proceedings and gave their consent for so far as recording is concerned. That is the finding of both the courts below. Therefore, this judgment's ratio has been made applicable to the extent that when the parties themselves have taken out the preliminary decree shares from the purview, participated in the consolidation proceedings, there's no question of reopening it in the final decree proceedings. That is also the case in the present. Therefore, that judgment has been made applicable and orders have been passed.
Then what is the proper course in this regard?
Well, since the final decree has been...
then the parties should come before the court,
my lord,
ask for an altered the preliminary decree to be passed so that the division can come. Consolidation proceeding does not end on the division of the properties. Does it end? Demarcation by metes and bounds.
my lord.
Does it? It's simply recording of the shares.
Right.
That's all.
That's all.
Like a preliminary degree.
Yes.
So in a partition suit, that's a unique concept is there can be more than one preliminary degree in a partition.
About that. So therefore,
Why not?
Yes, more than one preliminary degree.
So they could have asked for a alteration of the preliminary degree. If it is not, then what will happen? Final degree proceeding will abate because of that.
It will not abate, my lords.
Definitely. And the court has proceeded that the final degree proceedings are in the nature of an execution. I am unable to understand
that is not correct.
These fundamental principles. There's a basic principle.
That is there.
It's a continuance of the suit.
This judgment has only been taken resort to by the courts
where
below.
the parties consciously executed the sale deed.
But here also that is
parties.
But here, in fact, that is also the case.
Particular consolidation proceeding order. Then the court has said that once you have accepted it and you acted thereupon, now it is too late that you cannot resile therefrom.
But this is also exactly the same case. Your Lordship,
it's simply a recording.
Your Lordship will kindly appreciate. Now, in the consolidation authorities, my lord, it was...
So they have declared the rights that he is entitled to 3 decimal of land or whatever. He is entitled to 4 decimal of land. He is entitled to...
But he should have brought it to the knowledge of the authorities.
The thing is, final degree is means that they have to separate those shares.
That's right, my lords. But the final decree will be in terms of the consolidation ROR now.
That can a civil court act as an executing court of the authority's order? Can he?
No.
So therefore, my lords, the final decree proceeding was dropped.
There must be an alteration of the preliminary degree by consent of parties.
That your Lordship can observe.
What observe? And then he has ended. That should go.
He could not have ended. He could not have abated the proceedings. Because abatement of the final decree proceeding is unknown, my lords, especially with the consolidation.
Even after the preliminary degree, if there is any parties who died, there cannot be a concept of abatement in the final.
Absolutely.
In a partitions.
Right. But here the specific finding is, below. Well, I'm not referring to the impugn order. The specific finding below
The
is
difficulty is that you are representing only one.
One.
If we allow this, because we are going to set aside the order. Holding also that no revision lies.
Right.
Who approached the revisional court? You.
Yes, my lord. Sir.
You are a mischief monger.
They said,
if you are a mischief monger, how can you take this plea? Why you approached the wrong forum? Can you now take a plea that this forum did not have a jurisdiction?
no, that I cannot, because
we don't know what to do. Can't you say, because they are your, can you not take their consent?
That's because fresh notices have not been received by me, my lords. I traced out the file because I could, the name did not appear on the last
It's
day.
not necessary, sir. Why fresh notice at every stage?
Which originally had only appeared for this opposite party number 1 now, who was.
Then who was representing the opposite parties? Other opposite parties?
no. They appear for that.
Yeah, okay. Fresh notice sir, नहीं होना अभी short return. It's if a short returnable notice is issued, my lords, to these at least these contesting opposite parties, my lords. My humble submission would be that would suffice, my lord. Because
Who's contesting?
He's, my lords, so far as, because I don't have the consolidated cause title, but
The
1 to 6
title is also defective, sir.
Yes, that will be good.
It appears from the record that several amendments, several
Item number 4.
Your lordship is fixed to the Friday thereafter.
Notice.
20th. Obliged.
Yes. 203. Other matters. Yeah, it's just 1, 2, 3.
Item 4.
That
Item
item
number 4.
on the last occasion I was appearing in that case. In fact, my lord, I am unable to contact because file is not with me. My name is there only because I appeared.
So we are.
In fact, I have
dismissing
no instruction. Your lordship.
So we are dismissing you. None appears. Dismiss for default.
Yes.
Interim order, if any, stands vacated.
Item number 5.
Your Lordship, I am appearing through VPBs. Your Lordship, no instructions from the client, Your Lordship. We are not able to contact the client, Your Lordship.
I am appearing opposite part number 1, 2, 3.
Recording the appearance, dismiss for default. Let them come. Ask for a restoration. We'll see to it.
Your Lordship.
Well. Item number 6.
Six bullets, the petitioner is the defendant in a suit for declaration and recovery of possession.
Declaration of what?
This declaration of title, my lord, and recovery of possession. The case of the plaintiff opposite party was.
So section 5 of the Special Relief Act.
Yes. Now the case of the plaintiff was that an area of 900 square links.
This is the nature of the order which you are telling.
Yes, my lord. Well, may I just come to that order, just explaining the.
Just tell me the nature
Yes.
of the order.
Now, my lords, in this order, this arises out of an execution proceeding. In an execution proceeding, an application was filed by the decree holder.
The decree for eviction was also passed upon declaration of your title.
Yes, my lord.
Then execution.
Execution. In the execution, an application was filed to delivery of possession of that area which was declared in favor of the defendant. There, a civil court commissioner was deputed, and he filed a report saying that I am in occupation of 900 square links of land.
You suffered a decree or you?
I suffered a decree, my lords.
Suffered.
I suffered a decree. I am the judgment debtor. My lords.
Tell me that.
My lords. I'm sorry, my lords.
Judgment debtor.
I'm a judgment debtor.
Yes, say that.
So, my lords, this report of the civil court commissioner that I am in possession of 900 square links and I am to be evicted following a demolition of a structure existing thereon. I challenge that report before this executing court, saying that I object to the report on the ground that the measurement undertaken by the civil court commissioner is erroneous. Procedures have not been followed. To which, Lord, that manual, that Amin manual is there. The measurement from the triangular measurements that has not been followed. The learned court executing.
They have not followed that fixed point.
Yes, fixed points from. Now, lords, the learned executing court, on the consent of the parties, accepted. Both parties were of the opinion that measurement has not been in fact properly conducted. So the learned executing court, what he did was, he said, all right, this report appears to be erroneous. A fresh measurement is to be done. And in the event there is any building standing thereon, it will be demolished. That is where, my lords, my grievance lies. Now, it's in the suit.
You wanted that you should be evicted from a land, but you cannot be evicted from the structure.
No, it's what my humble submission
so
is.
The structure will remain in air, and the land he can utilize.
No, I'm slightly on the different footing, my lords. What my humble submission is, my lord, when the decree was passed, the decree was pertaining to 90 square links. Now, how the learned trial court came to 90 square links is by virtue of a civil court commissioner. Now, my lords, the civil court commissioner who was deputed during trial filed a report saying that I am in occupation over 90 square links. So a decree was passed to that effect because the report was ultimately accepted as part of it.
I think the decree contains the entire boundaries of the 90 square.
My lord.
Butted and bounded on the north on the south, east, west.
My lord.
Why the army needs to be engaged for that purpose? They will go just find out that particular identity of the property, and
My
then if your building comes within that periphery, fair enough.
The interesting thing is, my lord, the challenge in this writ is twofold, my lords, if your lordship will kindly appreciate. One is that a civil court commissioner who was deputed in the first instance, once he is found to have committed an error in the procedure leading to measurement of the land, and once it is accepted by the learned executing court, you could not have issued another writ to the same.
Then you will have to forget Order 26, Rule 10.
Well, that is there.
Look at it, the provision, give it. Give it to him. Read loud.
It says procedure of commissioner. The commissioner, after such local inspection as he deems necessary and after reducing to writing, the evidence taken by him shall return such evidence, together with his report in writing signed by him to the court. Report and depositions to be evidence in suit, the report of the commissioner and the evidence taken by him, but not the evidence without the report, shall be evidence in the suit and shall form part of the record, but the court, or with the permission of the court, any of the parties to the suit may examine the commissioner personally in open court, touching any of the matters referred to him or mentioned in his report, or as to his report, or as to the manner in which he has made the investigation.
You are reading Order 26.
Rule 10.
Rule 9 also you read.
My lord. Commissions to make local investigations. In any suit in which the court deems a local investigation to be requisite or proper for the purpose of elucidating any matter in dispute, or of ascertaining the market value of any property, or the amount of any mean profits or damages or annual net profits, the court may issue a commission to such person as it thinks fit, directing him to make such investigation and to report thereon to the court, provided that where the state government has made rules as to the persons to whom such commission shall be issued, the court shall be bound by such rules. Now, let's.
Now, what is the effect? Can he not appoint the other if he rejects the application?
Let's other in the sense, my lord.
Give it to me. I am giving
Mal.
you a promise. Extra copies not here.
Let's have a copy. Oops. Oh. And
yes, I was inviting your attention to subroom 3 of.
But let's I have a copy.
26 Rule 10.
Let's have a copy. Let's have a copy. An online copy.
Order 26 Rule 10 subroom 3. If the court is dissatisfied with the report,
it may direct such further inquiry to be made as it shall think fit.
If it is dissatisfied with the report, it can direct the further inquiry to be made.
So it's further inquiry, but here, my lords,
means the exercise has to be done afresh.
I'm not agree with the exercise afresh.
How can court direct the further?
No, my lords.
Because both of them has agreed that this report of the civil commissioner was not in tune or not in conformity. Then the court has appointed another civil commissioner and to go and
not another, my lords, the same person.
Maybe.
Because that is where, my lord, the grievance, my lord, is
followed the principles.
Yes, my lord.
Let him. There was no other allegation against him that he was he was partial, he was lopsided.
So the thing is, my lord, this particular commissioner, my lords, in the first instance, not only did not follow the procedure relating to measurement.
Now he has to follow. He has been apprised of the fact that you have to follow the rules. Where is the difficulty? Had it been that there is some allegation against the commissioner for the position.
So there is allegation, my lords. The reason being, my lords, the commissioner, my lords, in the first instance, not only measured the property erroneously, he also went behind the decree saying that he demarcated 900 square links, which is not even the decree of the learned trial court. And the second fold is, my lord, what the learned executing court has done is,
let them go. The impartiality, you will examine it when he submits the report. If you have any objection to the report.
because what your lordship will see the direction at the end of the order. Your lordship will kindly see what he has directed is, my lord, the learned executing court. Let's see, your lordship will see page 38.
Yes.
And in fact, the paragraph starts from the earlier page, page 37. It says that, may I just humbly submit, may I just read out that paragraph. It is the specific case of the JDR that the commissioner who measured the land during trial should measure the land at the time of execution. During course of hearing, the learned counsels from both the sides admitted that Sri Gangadhar Naik has not followed the measurement of the previous commissioner who was appointed during trial, and both the counsels also agreed that a fresh writ be issued to Sri Naik with a specific direction to measure the suit land according to the earlier measurement as per Exhibit C4 to Exhibit C9. The report submitted by Sri G.D. Naik appears to be wrong, as he was directed to demarcate only 90 square kadis of land, but he has demarcated 900 square kadis of land. For just decision of the case, it will be
correct. That
Ma'am.
is the correct one.
Ma'am.
That decree is for 90.
Yes. That I'm also not agreeing with us.
That's all.
It is just and proper to issue a fresh writ to Sri Gangadhar Naik with certified copy of the decree exhibits.
Because he has gone to 900. Now
That's
he can
right.
restrict to 90. Where is the
90.
difficulty?
No, but that was my prayer, which is my prayer is allowed. So far as that part is concerned, my prayer is allowed.
So,
subsequently, what the learned executing court says is, with the direction to demarcate the 90 square kadis of land as per the exhibits and the possession of which is to be delivered to DHR, there's no difficulty. There shall be specific direction in the writ of delivery of possession to bailiff of the court to demolish the structure, if any. This was nobody's case. This was nobody's case. This is not even the case of the decree holder. Now, this is going behind the decree because at the time of passing of the decree, there was nobody's case that there's a structure. And further says, if any found within the area of 90 square links, and to put the DHR in possession of such land. In other words, when you're resending the commissioner for measurement, and in the absence of having a report so far as the structure standing on that the 90 square links is concerned, my humble submission is there could not have been a direction to demolish the structure, if any, because then I will not have a chance to examine the commissioner. But that is the only
we are modifying that portion.
My
that he cannot.
My
it reminded me of the oft-quoted and celebrated price of the structures has been determined. Yes, with these observations, the writ petition is disposed.
There's one more thing. There's a particular name has been mentioned as the civil court commissioner. In case he's not available or he's not on the list anymore, well, it is open to the court to appoint fresh. Yes, absolutely, Milords.
Don't dictate the
But-
executing court.
No, but in fact, I am in favor of executing the decree, Milords, as an officer of the court.
Yes,
Because that particular person may or may not be alive, then it will has to come back to your lordship for a
whatever.
Milords.
Yes.
Item number 7.
In item 7, my lord, I am in the VC. I am in VC, my lord.
Yes, sir.
In item number 7, I am appearing for the opposite party.
Sir, who is for the petitioner?
And my lord,
E.P. Mishra, Mrs. S. Ghosh, E.R. Panigrahi, anybody knows them? Anybody knows them?
I was also asking Mr. A.P. Mishra, he told that brief doesn't belong to him. Ambika Prasad Mishra, he is guessing that.
What is Okalandama must be here. His name is reflected. This is for the, yes, no, see. It's for opposite party. Where is the Okalandama for the petition? Must have been annexed with the petition, yes. Oh. No. The administrative notice has come. Who is the first name? Mr. E.P. Mishra. Sir, whether you know Mr. A.P. Mishra?
A.P. Mishra, my lord, the person I know that he denied. Ambika Prasad Mishra, he denied that he is not the lawyer in the for the petition.
No, he has signed the Vakalatnama. Then we are directing that I do not know, then the administrative notice is to be given because the other advocate and record now is no longer an advocate. What to do? It appears from the record that one of the advocate and record dismiss for the permanent.
Item number 9.
May I please, Your Lordship?
9.
On behalf of Mr. A.K. Nandamila,
Yes.
in pursuance to Your Lordship direction dated my lord 12/5/2011, my lord, I filed recusals, my lord, but nobody has appeared till date, my lord.
12/5/2011,
Yes,
sir,
ma'am.
more than 14 years has
Yes, ma'am.
gone. Now more than you are for whom?
I am for the plaintiff, my lord, the petitioners,
Petitioner.
my lord.
What is the challenge in the
Challenge is made, my lord, against the order allowing a petition under Order 1, Rule 10 of CPC, my lord.
who has been implemented or who have been deleted? Who
The opposite party number 5 and 6, my lord.
have been implemented?
Implemented, my lord.
Who
Against-
are they?
They are the secretary and president of the village, my lord. My
Your suit is you are a
You-
bank.
Yes, my suit is for declaration of my right, title, and interest basing on a registered sale deed mill.
And what is the defense case?
The defense case is that, my lord, the state authorities, my lord, the defendant number 1 to 3, the collector, BDO, and Tahsildar, they have appeared, my lord. They have filed their WS, my lord. After that, my lord, the president and secretary of the
No, what defense they have taken? Just it depends upon that.
the opposite party number 5 and 6 have taken the defense that they have purchased the land by way of a unregistered sale deed by plain paper deed.
Unregistered sale deed.
No. That is their case, my lord. That is reflected in the order itself, my lord.
From whom?
From the person from whom I purchased the land, my lord.
So they all you are there is a common vendor.
My lord.
Common vendor is there.
My lord.
You have purchased, and they say that they have also purchased.
My lord.
Have they said that sale deed or they have said agreement?
They have said sale deed, my lord.
Sale deed without any registration.
Without registration, my lord.
When they have purchased?
They have purchased as per their advertisement, my lord, in 1955, my lord.
55.
My lord.
And when you purchased?
I purchased in 1971, my lord.
Be a Registration Act or PP Act, both. In the area.
Area 23 decisions, my lord.
In which district or where? which
Sundargarh district, Raidi village in Sundargarh district, my lord. It is scheduled tribe, my lord. That's secret.
Whether this section 17 was extended to that area in 1955.
Regulation to
What was the value of the property?
value of the property is 1300 rupees, Miller.
They have shown how much?
They have not filed any document. They did not file any document.
What are you talking?
Yes, my lord.
Where is the written statement? Is it in English or?
My lord.
Written statement is in English language or what?
English language, my lord.
Have you annexed?
No, my lord, I have not annexed.
Then how do I know?
No, my lord, I have not annexed it.
So why you are embarrassed? Let them go and fight. Expediting the suit. What is
Yes,
the
yes,
difficulty?
your lords. My lords, yes, I agree.
The instant repetition is the Yes.
Matters in supplementary list arbitration matters.
Sir, I am from VC, my lord. Item
No.
1, my lord. Item
Item-
1, I am from VC, my lord.
Item 1, your lordship, I am for the opposite part and I am filing the counter in the course of the day. Already I have filed. I'll serve a copy on my learned senior. If my
Item 1.
lord next week, then
Item 1 arbitration matters.
application. May split.
Yes.
Item number?
Once.
So who is for the petitioner? Mr. Jyotendra Kumar Mahapatra.
Yes, sir. Sir, I am from petitioner. I am from VC, my lord.
Oh, thank you that you are on VC. But where is your counterpart here?
I have not received the counter, my lord.
My lord, I'll serve a copy on my learned senior.
But how he will give?
I will collect, my lord. I will collect. I will collect.
The counsel appearing for the opposite party number 1, 3, and 4. No.
1, 2, and 3.
First before engineer, then AC, then chief engineer, and then secretary.
This is an application under section 11 of the Arbitration Conciliation Act, level 6 within the Arbitration Conciliation Act 1996 for appointment of an arbitrator as the dispute
Item number
In A, time limit. Section 29A, time limit.
Same, my lord, 6 months plus 1 year, my lord. 6 months for completion of proceedings, then 1 year, my lord, for that. We will follow, my lord, the time schedule.
Deeply obliged, Your Lordship.
item number
Item number 3, I am for the petitioner. I am appearing through petitioner.
Item 3, Your Lordship, 1 week time to file the counter, Your Lordship. 1 week time. Last time, Your Lordship was pleased to issue notice. I have sought for instruction. 1 week time, I'll file.
The respondent appears.
Clause is at page 17.
So notice has not been issued.
No, my lord, it is a fresh matter. Notice is notice.
2 weeks.
My lord, may I submit, my lord, my Union of India is a party. I am
Yes, my lord.
allowed to serve copy to the. Yes, my lord. Union of India is a party. I can accept notice for Union of India.
Then record his appearance, waives the notice.
This is custom. Your lordship, I have already filed my appearance number 2.
And the rest is the only Union of India.
Yes, it is CPW of India. Yes, ma'am. Central Public.
Yes. Just say the record his name, appears for the Union of India and waives the service of notice. The advocate and record of the petitioner is directed to serve the copy of the application upon him. Okay. Within.
$37, my lord. Clause 16, settlement of dispute. It's at the bottom paragraph.
Just one.
Yeah, my lord.
Oh. Yes, 137.
137, my lord. At clause 16, settlement of dispute, and the next subsequent page also at 16A. Both of them consist of arbitration.
Service. Service.
Great, my lord. Great.
2 weeks.
Much.
item 6.
Item 6, this is for fresh admission.
Where is the arbitration?
Arbitration clause is at page 42, annex 1.
Page
42, my lords. Clause 7.
relation to an agreement for sale.
Yes, ma'am. Development agreement.
There is a notice under section 21.
My lord, it's at annexure 7, page 70.
Service 2 weeks.
For orders, item number 7.
Please, Lordship. Lordship, we have filed a IA 18 of 2025 on order 5 to 20 for substituted service to opposite party number 2.
This is an application taken out by the petitioner.
Last to Lordship.
Item number 8.
Wait, please, your lordships, my lords. In both the matters, my lords, at 8, my lords, your lordships filed the last order dated 18/7/2025. It directed me to take notice by two modes, my lords, by filing postal requisites as well as via electronic mode. Now, my lords, I have complied with both the directions, but so far as the postal requisites is concerned, the notice has come back with the noting that it has come back with a noting, my lords, that no such addressee.
Oh.
And in fact, my lords, via the electronic mode, I have served your lordship's order as well as the petition copy in the email address through which the parties had been corresponding throughout. These are the through memo, my lords, I am filing in both the matters. The two email addresses where I had served copies and the copy of the email I have given, my lords. And from the record also, the same email address appears. Email address, if your lordship sees, page number 44 of the first petition, my lords, ARPP 51, the same where I have delivered it. Amber Furnace Inch at the rate readymail.com and amber.furnace. My lords,
Where is the arbitral agreement?
my lords, arbitral agreement, my lords, is at annexure number 1, my lords, and the clause would be, my lords, at page number 32.
Clause?
Clause number 22, my lords, page 32, clause number 22.
When that email was uploaded?
That email, my lords, I had sent on 30th of July.
Can you find the alternative address?
My lords,
Where he's residing there or
my lords,
sorry, working for gain there?
yes, my lords, all my correspondence, in fact, my section, the notice invoking arbitration also I had sent in there, my lords. But I've been told by my instructing counsel that always he tries to avoid the notice. So that has been the modus operandi of this respondent, my lords. That is, my lords. And it's a company, my lords, from Bombay, so Mumbai. My lords. So
The address is of Mumbai.
yes, ma'am.
Where is the section 21 notice?
21 notice, my lords, will find it. Page number annexure 4 series, my lords, page number starts from page number 47 onwards. Detailed notice I've sent. Mhm.
Pursuant to the
Mr. P.R. Barik, who is reasonably senior member of the bar. P.R. Barik. Peace Port Schedule. Time limit 29A. Yes.
The second item is also there, my lords.
Same.
My lords. Only the contract date and the date of notice invoking arbitration is different.
Give that.
My
One
lords.
is 22nd of February 2022. What is this?
This is, my lords, 13/6/2022. And
the execution was same, furnace.
yes. Furnace little bit different, my lords. I'll tell you, lordships.
Contract. Yes.
I've described
Item-
it.
Same.
Same.
Both.
My lords.
Item 9.
I'm grateful.
In item 9, I am for the petition. Notice has been issued, noting that neither AD nor the
We
undelivered.
have not received anything. The service is not complete. Matter to appear in the next week.
Okay.
Item 10.
Item 10.
Yes.
Manoj, I think, Manoj, here Justice Nageshwar Rao had been appointed as arbitrator. He recused from the arbitration, Manoj. There has to be a change in arbitration.
We have received on behalf of OP number 1. But in the meantime, what I am told is because it is Intercept brothers, one of the brothers has initiated for like a mediation. So subject to lordship's, if it can be taken up 1 week after, in the meantime, we'll also file our appearances because on instruction I am stating all this. So subject.
He is taking. Now we are thinking of not made arm, but arm made.
So, subject to my lord, whatever
arm was there, that if the mediation fails, then the arbitration can be explored.
Yes.
Now, just reverse.
Just the reverse in the midst.
Made. Where in the arbitration proceeding, if there is a possibility of mediation.
Well, it's amongst brothers, my lord, so maybe disputes can be settled.
Lordship, I'm appearing for the OP number 4 and Mr.
Why you are fighting? Go and sit across the table.
No, that is what my lord.
We're filing our appearance.
File your lordships might take it up on
next week.
Next sitting. My lord, next week will be 15th as a holiday.
So
So
that means
next sitting,
obvious-
your lordships next sitting.
Obvious.
Deeply obliged.
Item 11.
My lords, my appearance may be not.
Yes, sure.
Okay.
I'm appearing for the OP number 3, my lord.
These are all the fresh matters.
No, my lord. This matter appeared for the second time.
You are appearing for?
I'm for OP number 3, my lord.
Who is for the petitioner?
But I was in item number 10 only. In 10 only.
Oh, in the previous matter.
Yes, previous.
Record his name. That
Item 11.
Item 11. On previous occasion, my lord put forth a query with regards to the sufficiency of the payment of stamp duty.
Now, interplay judgment you have found out.
Yes, my lord. But
What the interplay judgment says?
Interplay judgment says that, my lord, if it is insufficiently stamped, then it can be impounded. The impounding fees shall be paid. And
when? At what stage?
It can be, my lord, it can be at the stage when the matter is pending before this honorable court. That at that moment also it can be impounded. But my lord, my respectable submission to that effect is that in the present case, impounding is not necessary because as per the Odisha state amendments to the Indian Stamp Act, any agreement to sell without delivery of possession, my lord, minimum 10 rupees of stamp duty is enough. And the agreement at hand is on a
There is
paper
a
of
judgment of a single bench. What do you have to do? Then the first question is whether it is really an agreement for sale or it is a sale agreement. Distinction.
But to that effect, my submission is that it is an agreement to sale, but the possession, because of this agreement, has not been delivered as of yet. If it would have been coupled with the delivery of possession, my lord, then the full stamp duty would have been paid. That is 2% of either the agreement value or the value, market value of the property value, whichever is higher. My lord, may peruse the article to that effect given in the schedule of the Odisha amendment to the Indian Stamp Act. It clearly states that if it involves delivery of possession, in that case 2% of stamp duty will be paid.
Article 5.
Article 5. But this case would be covered under the category C, my lord, which is not prescribed. Also, my lord, the IGR website, which that also.
Have you seen a single bench judge?
I humbly apologize. I have.
Please go and see.
Yes, ma'am. Reference. I'll take the
Justice Panik's. The distinction was sought to be drawn between us. SMST was declared to be bad law. Everything was declared to be.
Yes, ma'am.
Then what you read?
As per 235(4), my lord, it says that any objection in relating to the stamping of the agreement fall within the ambit of the arbitral tribunal.
That is means section 16. He will go his rule its own jurisdiction.
Yes, ma'am.
So I am at the stage of section 11. I invited you 3 times. I asked you, have you read interplay? Have you read interplay? You said yes. You have not read interplay.
But then, my lord, I'll apprise this honorable court with regards to all the recent judgments, including
This is the recent judgment. Thereafter, no other judgment.
Yes,
and if you want, I can give you on the fingertips. The first dispute arises from SMST.
Yes, sir.
The second dispute arises in the Garware polyester. Garware. Then there was Subhas Popalit. Then there was NN Global. 1, 2, 3 means 3 judge, 5 judge, and 7 judge. Now I think is the last one is
interplay.
The interplay is a 9 judge. Is a 9 or 7? 7. You have not.
I'll
What
again go
latest
through.
judgment you will read?
My lord.
Now, in recent times, there cannot be a constitution of such a large bench. So even if there is a judgment, is of a lesser quorum. That's the last law. So you have not read.
I'll again go through the judgment.
Oh.
I'll again go through the judgment.
Now I'm giving you another point. It says that because of section 16, it has to be decided by the arbitral tribunal. Let them decide. What would happen at this stage of section 9? Before the court? What will happen?
Your lordship, I have to very examine my nothing like that.
What will happen? Will the court accept it or will not?
I'll have to examine, my lord. I'll honestly answer, my lord. I have to examine.
This is not answered. Bombay judgment is somehow diluted by justice. Bombay clearly says, the special bench of the Bombay High Court says that yes, it does not require at the stage of Section 9 because this is really an interim stage.
Pre-arbitration. Pre-arbitration.
No. Section 9, 3 stages.
Yeah.
During,
and after.
After is restricted. So long the application is not filed. Read the Garware judgment where Bombay High Court judgment has been quoted. But I do not know what would be the meaning therefrom in negative and in affirmative. I do not know. Yes, so what to do? Now we have done our academic class.
Vice Alert, a request for an appointment. Yes, my lord.
For service.
Service, my lord, it is sufficient. The notice is sufficient. It was reflected in the office note as well. But she is not appearing.
What is the agreement for? Sale?
Yes, my lord.
Yes.
The agreement is at Annexure 1, my lord. The arbitration.
There are many orders passed. This matter is pending since 23.
Yes, my lord.
Not disposed of.
Not disposed.
This is an application. This is an application section 11. You choose any name. The claim is of 65 lakhs and the execution of property. No, don't consult him.
Oh,
You choose
independently. It will not be proper because I am also one of the arbitrators in the list.
No, that's true. Not you. Exclude yourself. Give any other name. Tell me the name.
Prakash Ranjan Barik.
No. Oh, we have already appointed him in one matter. Any other name? In the previous matter, he has been appointed. So
There are certain names who are no more there. Somardarshan Man.
we need you just tick so that we can refresh.
Kamal Bihari Ponda.
Yes. Yes.
Can I suggest there are certain those who are not
names
there.
who are not in the world.
Yes.
You just make a pencil tick mark. Just give it to him.
Yes, ma'am.
Pencil tick mark. Give a pencil.
Yes, ma'am.
So that we can delete and fresh. Same. Schedule 4 remuneration or award within section 29 capital A. Yes. Yes. Any. Let us stop here.
Yes, the next matter is again that, my lords, which has been rolling for some time. Substituted arbitrator. If you will.
Yes.
So they have filed a notice of submission today. They have served a copy. So what I would suggest, can it be on 22nd so that we are both parties are ready?
Don't all this.
Grateful.
Obliged, Your Lordship.